Integrate NYC versus State of New York. Counsel?
May it please the court, Mark Rube for the state appellants. May I reserve 2 minutes for rebuttal?
Yes.
State appellants and plaintiffs share much common ground in their aspirations for the education of the city's children. The Education Department has sought to combat systemic racism in the state schools, recognizing it is a complex problem deeply rooted in our history, culture, and institutions. But plaintiffs' claim under the education article for court-ordered relief is not the proper means to achieve those common goals. In NYCLU versus state, this court held that a plaintiff must plead a clear articulation of the asserted failing of the state. Plaintiffs have failed to do so because their complaint turns on such questions as which books are used in school classrooms, which teachers are hired, and how students are assigned to schools. Those matters are committed to local control under our state's system of constitutional government. That's demonstrated through the history of the education article, the text, and this court's precedent.
Can I ask you about a different, over here, a different part of your argument? It seems to me that both the city and the state are arguing that the other is responsible for any failings. I know you argue there aren't any failings, but what are we to make of that?
Well, this court is routinely asked to determine questions of allocation of authority between state and local government. For instance,
so you're not saying no one is responsible. You're saying that the your counterpart is instead responsible?
well, what we've said is that it's a complex problem that is a result of hundreds of years of inequity.
Right, but if a case comes to us, you know, with both the city and the state, that's a joint issue that we have to resolve.
Right, and so as in Tax Equity Now New York, which this court heard last year, which concerned alleged racial disparities in New York City's property tax system, there the court was tasked with the same question, and it concluded that the alleged deficiencies were attributable to the city and allowed claims against the city to go forward, but not the state. And that
Didn't we reject that in CFE 2?
Well, what CFE 2 concerned was questions of funding, and it said when there are allegations of funding that the state is ultimately responsible, regardless of how the local government uses the funds to which it is given.
Well, so take your example about curriculum choice. Is there a situation where let's say New York City school district could make a curricular choice about books that was so extreme that the state would say, wait a minute, we have a responsibility to step in here?
Well, certainly there would be remedies under the Human Rights Law, the Equal Protection Clause, if,
No,
for example...
No, I'm not asking about what remedies a private person might have. I'm asking about a responsibility the state might have to step in and say to New York, no, this curricular choice is not something you can teach here.
Well, the Office of the Attorney General enforces the HRL and enforces non-discrimination mandates. So
How about the Department of Education?
The Department of Education has various tools. There's carrots and sticks. In NYCLU versus state, this court discussed the registration review tool, which is a tool that the state can use to have enhanced control over underperforming schools. And what this court said in NYCLU versus state is that that's not the type of remedy that is the judiciary oversees or manages, but that is left to the state and the democratic process to determine whether those resources, how they should be allocated in that manner. If I may briefly turn back to the question of the history of the education article, it arose in the 19th century in the context of the legislature for much of the 19th century was inconsistent in whether it provided adequate funding for schools. And in the Constitutional Convention, the people took that discretion away from the legislature and gave the courts a significant but limited power to ensure that adequate resources are put into state schools.
But where do you get the adequate resources part of that statement from that history?
Because that's what it arose from the free school movement, and parents before the education article often had to pay what was known as the rate bill, which was they had to cover teacher salaries, they had to cover whatever the state did not cover. And the education article said that the state is responsible so that all children can receive a free education, and that's why it's grounded in funding. The text of the provision as well
It's
speaks.
actually the free common school
Free common
movement, right? And what significance do you give to the word common there? I mean, there was a common school movement, right? And
Right.
part of that was for standardization.
Right, and what this court said in refit is that it constitutionalized the existing system at the time of the state-local partnership, where local governments were given significant control over what kind of education would be provided. And this was grounded in what was said in Levittown, the presumption that the best choices in education are made when local needs are accountable and are in charge of making those kind of
So
determinations.
the only responsibility of the state would be to ensure a certain amount of money sufficient in itself to secure a sound basic education is pushed out the door, and then we're done.
In Painter, this court said, and other precedents, that the state has satisfied its constitutional obligation when it's provided adequate resources. That said, of course, the
Because
state.
in that context, weren't the challenges of that nature? I mean, in a case where you've alleged you haven't provided sufficient resources, then they've satisfied their obligation by providing sufficient resources, right?
Right, and in NYCLU versus state, this court said that there has to be a clear articulation of the state's failing, that.
But is it your position that only funding could make out a violation of the education article? Could a curricular choice never rise to the level of failing to provide a sound basic education?
Well, that's our position, but the court doesn't need to draw a bright line.
Just to give you an
rule.
example, if I can, suppose, and hopefully this is far-fetched, that the schools decided, for example, that they would only teach math to boys and not girls, or vice versa. I realize there would also be, I would suppose, a host of other claims one could bring to challenge that, but would that be something that could make out a failure to provide a sound basic education?
Well, as Your Honor noted, there would be a number of other
Right, but
grounds.
focusing on the
And
education
And I
article.
think the court could leave that open, that question open today, because what this court said in CFA 2, one example it gave was if the state passed a statute that it would not fund schools after fifth grade, which is similar
So you
to Your
acknowledge
Honor.
there might be
There
some
might.
choices that could be so egregious, although not a funding determination specifically, that they could still make out a violation of the education article?
Well, I would say that there would be more grounds for finding a violation of the education article in that case. I'm not conceding that there's anything beyond funding, but there's certainly, this court could craft an opinion that would leave that question open for another day, as it has throughout its jurisprudence on this issue, leaving the contours of the education article open for future challenges.
I think your light is on.
Thank
Thank you.
I will be, thank you.
May it please the court, Jeremy Schwader for the city defendants. I'd like to reserve 2 minutes for rebuttal, please.
Yes.
Okay. The first department's decision was based on a series of incorrect factual interpretations as well as incorrect factual understandings about what plaintiffs had alleged. On each of plaintiffs' claims for this court to affirm, it's going to have to break new ground or it's going to have to alter controlling precedent. We can start with the education article claim. Now, there are really three principles that go together here that are textual and prudential. You can start with the text. A claim only exists against the state. That is textual. This is the education article says the legislature shall provide for the maintenance and support of a system of free common schools. You don't have to look any farther than that to know that this can only be a claim against the state. And I'd like to answer the question about what would happen if it is my colleague here is saying this is all a local school district issue, well, there are levers that the state can undertake to force compliance if a local school district is not doing what it needs to do. Education Law 306, the commissioner can remove local school officers and it can withhold money. That's a serious stick right there. Education Law 308, the commissioner can
And if it
institute...
doesn't do those things, why are you off the hook?
Well, to begin with, a claim can only exist against the state. So that there is no claim against a local school district. That's Donahue. I mean, you can just look to Donahue, and you can look to the text. I mean, Donahue said there's no duty flowing from a local school district to individual pupils. So a claim would go against the state, and this goes to the second and third part. It has to relate to funding, because we want the state, the claim has to be against the state, and it has to relate to things that the state can control. And we do not want states getting involved in local school decision-making. That's a through line from all the decisions of this court. So that's why there has been, and the third part of this is that it has to be district-wide, and that goes to the same idea that we want this claim to be about funding, we want it to be against the state, we want it to be something that the state can control, and that is funding at a district-wide level. That is a neat, understandable, practical and prudential way to approach these cases in education law. And this court has never found that a local school district can be responsible under the education law. I think that's the making new law part. It's also kind of breaking the text part, because the text says it is the legislature that can provide. And if there's concerns about what a school district would do if it wasn't obeying the commissioner, the education department, there are levers that can be taken to force that. I want to bring up that there is another angle to this, and if the court is not interested in kind of making a categorical ruling about whether this can be about funding, whether this can be about whether a local school district can't be sued, I think that there's a real causation problem in the actual allegations here, and this goes to the factual part of how the first department erred. I think that this court could really just say, it's not enough if you're alleging novel inputs, which everybody acknowledges these are novel inputs here, to just opine that this is what is needed for sound basic education. You're going to have to also have some coherent way of saying these inputs we're alleging cause the kind of outputs that this court has recognized are what we know to be the things that tell us that there's not a sound basic education. And I think it's really important here to look at the complaint, because the complaint, 90 pages, has one paragraph that alleges outputs, just one. And I'd like to point the court to it. It's on the record to 48. It's paragraph 83. And basically, 4883. That paragraph alleges two outputs. One is low graduation rates. The other is inability to get advanced Regents diplomas, which nobody would ever consider that part of what's required for a sound basic education. There are 0 paragraphs in the complaint that allege causation, that allege that their inputs are what have caused these things to happen, or like a deficiency of those inputs in the New York City system. So there's a serious causation problem. What their kind of theme in their complaint is to basically say, there are studies that show that X input will help outputs, but they never actually tie it back to something going on in the New York City school district. They never actually say the deficiency of this input is causing a deficient output in New York City. And you can look
What about their argument regarding the standardized tests, which is not about deficiency, it's about choosing something that they allege is a barrier for students to access particular resources in the school?
I think the allegation there, first of all, I think that's more about the equal protection, but to the extent
Well,
it goes
might be
to...
more about the human rights law claim, which I would like you to address.
May I finish this point?
Please.
Quickly? Okay, because that allegation would only go to the idea of, can they get into the most selective schools? Nobody would ever say that under the education article that that's what's required, that you must be able to get
Well,
in.
isn't it the allegation that this is a resource, those gifted and talented programs that are open to students if they succeed or excel or otherwise reach whatever cutoff you have on these tests.
But-
And the test, I mean, in employment law, tests are challenged all the time.
I'd like to get to that.
The tests
I'd like to
may
get to that.
indeed affect one's access. In this case, they're saying access to a taxpayer-funded resource.
Yeah, but that may go to the state
Which
human
you've
rights
made
law claim.
exclusive through a testing protocol which they argue is flawed and unconstitutional, but let's see
That
what
all
you're saying.
goes to the equal protection human rights law claim. As it relates to the education article claim, there has never been, I mean, many of these, of the decisions from this court have basically said, we're talking about a sound, kind of a floor, right? Nobody would ever say that it's an education article violation if you are unable to get into the most
Why
selective
isn't it the
schools.
floor to be able to equally compete for exclusive programs? Why isn't that a
That's-
floor?
That would again be the court moving in a very different direction.
Okay, but I'm asking, why couldn't?
Look.
Is there something that we have said, or something in the education article, or anything else you want to point to, that would prohibit such an interpretation?
I'd start with the text. The legislature shall provide for the maintenance and support of a system of free common schools. That's all it says. And that has been interpreted.
Well, how is it a free common school if indeed a particular population doesn't have equal access to compete for a resource that's supposed to be open and available to all students if they satisfy the criteria?
This court has said over and over again that equality is not the goal of the education
No,
article.
I'm not talking about equality, unless you mean equality in the sense of the opportunity to compete with everyone else for those slots.
They have the opportunity to compete with everyone
Well,
else.
that's their
in those slots.
argument, that they really don't.
That's not part of the case anymore. That's not part of the case anymore. The arguments that, oh, we don't really know how to prepare for this, or those kinds of things, that is out of the case with what the First Department said. So when you push aside all those parts of the complaint, you're left with one paragraph of output allegations, and really only one valid output allegation in there, and 0 paragraphs of causation. And the First Department erred here because it gave them credit for causation that didn't exist. If you look at 589 of the record, the court said, according to plaintiffs, a diverse curriculum and teacher force, sufficient resources, and affirming school environments are associated with improved outcomes. That's true. That's kind of we have studies that show that if you do this, there are improved outcomes. The wrong part of what the court said was the improved outcomes plaintiffs allege would include better standardized test score and increased number
What
of...
about, as it was indicated earlier, the question of the equal protection cause of action and the testing as to the city?
Sure. So let me go to the equal protection claim. There are some serious allegations, serious problems with finding that the allegations here show intent. And I think everybody recognizes they must show that there is an intent to discriminate. The First Department recognized that foreseeability is not enough. So what are the allegations related to the city? One thing that we have is a substantial number of allegations showing that the city has tried to prevent and taken measures to prevent the type of racial imbalances that are there. We've fought against the Heck-Calandra Act from the very beginning. We continue to do so. We have changed the discovery program.
But there continues to be inequities, right? So doesn't that amount to an equal protection violation, like the city's failure to address those inequities?
No, that's just,
Like you're
that's just
aware
disparate
of them?
impact.
What's
That's just
that?
disparate impact. And that's very different. And I think that is a fundamental error in the way that plaintiffs are approaching this equal protection claim, is that disparate impact is not the same as intentional. You need to show, this is Arlington Heights, you need to show all these different circumstances that would make you think that the municipality is changing course in some way, or it's not doing things the way it regularly does. All the evidence here shows that we are actually taking steps to try to prevent the racial imbalances.
There's not evidence, there are allegations, so let's get to that. As I understand what you were now arguing, you're arguing the merits.
Not at all, Your Honor. I'm arguing with their allegations. Because they need to, if they're going to allege equal protection,
Yes.
they have to show some sort of indicia that there's intent.
What is your understanding of their theory of intent?
As to the city, there is literally only one thing, and that is that we have not vetted the Shazat test well enough. That is the only thing that's related to the city. Everything else shows that the city is actually working against this, including that we're being sued by plaintiffs for the actions that we're taking in the discovery program. We're getting it from one side where we have these plaintiffs saying, you have to do more. And then when we do more, we're getting it from the other side from plaintiffs who are saying, wait, that's an equal protection violation, what you're doing. This all is pretty strong evidence, allegations, whatever you want to call it at this point, that we are not actually in that Arlington Heights factors. But let me go to the vetting. Okay, so there one allegation, it's on paragraph 95, page 57 of the record. That is literally the only thing that they say about the city. So that, because we don't control the Heck-Calandra Act. So they say that it's not well vetted. But this combines disparate impact and intentional discrimination in a way that is not appropriate. Because a disparate impact claim involves two parts. First, you have to show racial disparities, which we acknowledge exist here. Second, you have to show that there's not a legitimate basis to account for that, right? And that's when you're talking about tests, that's kind of baked into the allegation you're making, that there's something wrong with this test. But it's not a separate indicia of intent. It's all part of the disparate impact claim. So I think there's a real risk that if you allow this to go forward, you're kind of collapsing the difference between a disparate impact claim and a claim of intentional discrimination. And I think that's really the big problem with their claim as against the city. I think
Counsel, your red light's been on for a while.
Can I just address the human rights claim? I mean, because I think that's a big part of the case. If
You do.
prefer-
You've saved time for rebuttal. Why don't you take it then?
Oh, thank you.
Thank you, Your Honors. Paul Draper, arguing on behalf of the intervener appellant defending education. I'd like to reserve 1 minute for rebuttal, if I may.
Yes.
So at bottom, plaintiffs in this case claim that New York City's school system somehow creates a racial caste system precisely because it doesn't use race as a factor in admissions, teacher hiring, and curriculum development. That claim is as wrong as it sounds, and plaintiffs should lose their case for two reasons. First, their claims are not justiciable, and second, their claims fail on the merits. In my limited time, I'd like to focus on justiciability. This court has repeatedly said that this court is not capable of overriding the decisions of policy experts in matters of discretion and policy-laden decisions, and that includes education.
How do you square that over here? How do you square that view with the decisions in the CFE trilogy?
I don't think CFE undercuts that at all, Your Honor. I think I think CFE is very consistent with that. I'm not. Could
How
you
so?
maybe articulate? Sorry.
How so?
Could you maybe? I'm not sure why it would undercut it.
Well, if the proposition you're articulating is true, then why would the disputes in CFE have been justiciable?
Right, so I don't think, Your Honor, that there's no potential claim related to the education system that's not justiciable. The question is whether particular claims brought by a particular plaintiff.
Right, and why are these distinct from the types in CFE in a way that makes them non-justiciable in your view?
Right, so I think the reason these claims aren't justiciable, Your Honor, is because the plaintiffs here are not claiming any sort of discrete individual harm to them that violates a statutory or constitutional obligation. What they're claiming is that they would...
Wait, that's two pieces to that. Do you think they're not claiming any discrete harm to them?
I think they have not alleged, for example, Your Honor, that any of the plaintiffs here or anyone has been denied admission. For example, take their admissions arguments, has been denied admission to a selective school in New York City on account of their race. They argue that if the city adopted a different admission system that prioritized race over what the city describes as academic merit, then the city would achieve a more racially proportionate admissions outcome. But they have not alleged at all that anyone has been denied admission to a school on account of their race where they would have otherwise qualified.
Well,
That would put
haven't
this
they
case-
alleged that some of the schools, based on essentially geography, are in poorer shape and provide a poorer level of education than others do, and that those schools are ones that have larger minority populations?
So they've alleged that some schools are worse than others, Your Honor. That bleeds a little bit into the merits of the education article claim. This court has always said, to sort of touch on what my colleagues have already articulated.
I thought you were talking about justiciability.
Yeah, so I think the question about where to allocate finite resources is exactly the kind of discretionary decision that this
But
court
that
has said
was-
is not justiciable.
I think that was one of the questions, maybe a fundamental question at issue in the CFE cases.
Right, so the question, what is justiciable is if the city or the state has violated their core minimal obligations under the education article. That's not a discretionary decision. So the education article and what
Isn't that the
CFE addressed.
question before us?
The question, the plaintiffs have not alleged a violation of the education article that is justiciable. So a violation of the
Just trying
education
to
article.
understand whether that goes to an argument that they failed to state a claim, as opposed to that issue is not justiciable.
Well, I think they've done both, Your Honor, but I think it's important, this is why it's important to understand particularly exactly what their claims are. So their claim here is not that none of the students in the district, in the New York City schools, have access to a sound basic education because the state and city have failed to fund them. What they've alleged is that the state and the city have not allocated their finite resources enough to provide exactly the same standard of education to every student in the district. Even if you accept that claim is true, that is a question of discretionary allocation of resources.
So if
And
they
the education
allocated zero to some set of schools that were schools that had predominantly populations of color, that's discretionary, non-justiciable.
Well, if they did that intentionally on the basis of
Well, their allocations are intentional.
They've alleged a conclusory allegation in some of their
So
equal
wait, so
protection arguments.
justiciability turns on the same intent that the Equal Protection Clause turns on?
No, Your Honor. The justiciability argument, first you have to look and say, what are they claiming?
Yeah.
And then you have to ask, is that particular claim justiciable? The fact that
And
they
so
might be able to
a
allege.
claim that they have allocated resources in such a way that communities of color get fewer resources is not justiciable?
I think the claim that they've allocated, may I continue with if they are allocating resources with the intent of depriving students of a certain racial background of the minimum sound basic education required by the education article across the school district, that might allege a equal protection violation. But I think the two important things to understand here is that they're not alleging that students across the district of any race are deprived of sound basic education, because they agree, that what they're alleging is that particular schools in the district perform worse than other schools in the district. That is exactly the kind of thing that this court has said is not an education article claim, because the education article is concerned with district-wide failures. Once you get outside of that core education article claim, or any of these other things, once you get outside of an equal protection claim where you're saying that a particular student was denied admission, for example, on the basis of their race, even though they otherwise qualified, that would be something this court has said is justiciable and is required by the Equal Protection Clause. Once you get outside of that and you're arguing
your
about
red light's
discretion,
on. Got it.
then you're in non-justiciable territory.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Mark Rosenbaum on behalf of the respondents here. Your Honor, may it please the court, the issue before Your Honors this afternoon is simply at this very early stage, the beginning stage of litigation, whether or not we have stated causes of action, whether or not the amended complaint states that. Most of the discussion this afternoon from the other side, as well as their papers, are factual questions. And that, as Your Honor recognized, is precisely what the discovery and the process of developing.
With respect to the education article, do you have to allege a district-wide failure? And did you do so?
We do have to argue here, allege, Your Honor, a district-wide injury. The court said that, for example, in the NYCLU case where there were 27 schools. It wasn't a district-wide problem. That was a problem that Your Honor dealt with in the Artistry Ferrer case, where for Buffalo or Eureka, for unnamed districts, there was no statement of a district-wide problem. But we've done that here, Your Honor, because what exists in the New York City school system, hyper-segregated school system, one of the most segregated, if not the most segregated school system in the United States, is the creation of a two-tier system, district-wide policies of admissions, of enrollment, and of the provision of the basic inputs, which this court has recognized in CFE 2 at 909 through 914, and at 317 and 319 of CFE 1. That is a district-wide problem. And the problem is that predominantly these schools, these segregated schools, these unscreened schools, Your Honor, are not providing a sound basic education.
Can I ask you about, to follow up on your reference to CFE?
Yes.
My recollection, if it's correct, is that the complaint in CFE had fairly more specific allegations about output deficiencies. Is that a fair characterization, do you think? And if so, what are we to make of that in terms of the viability of the education article claim?
I want to be frank with you, Your Honor. I don't remember that case stating more specific outcomes. But let's talk about what the outcomes are that we've alleged here, because they more meet the standard of what this court has said is required. Here's what we say. Your Honor stated in CFE 2 one parameter. I'm going to go through all of them. One parameter, and that is graduation rates. The graduation rates for the kids whom we represent, for black and brown kids, is horrendous. 1 out of 4 kids who are black or brown are not graduating from New York City schools. That's 8 and 10% lower than white and Asian students.
And how is that tethered in terms of the allegations in your complaint to what I take to be the primary focus, or certainly a primary focus of your complaint, which is the admissions test for the selective schools?
Great question,
What's
Your
the
Honor.
causation link there that you've alleged?
I just want to put a pin in the outputs because I haven't completed all the outputs that we've described. But I want to answer your question directly, first of all. The core of this case, there are several pillars of this case. One are the tests that you all were talking about. We have alleged that those tests are pedagogically unsound. We have alleged that they are culturally and racially biased. We have alleged.
How does that go to a broader ramifications for students outside those who are applying to the specialized high schools?
The broader inputs, Your Honor, are essentially differential from what we're talking about regarding the test. We have alleged inputs with respect to instrumentalities of learning, teaching, curriculum, access to arts, sports, and extracurricular activities, and the physical plants of the schools. We have done that at paragraphs 100, 15 and 16, 5 and 6, 87 and 8, 88, 103, and 104.
And those are many numbers, but if you look at those allegations as against the CFE allegations, there's much more specificity as to computers and other hard-core instrumentalities.
I don't think that's correct, Your Honor.
Well, then I would suggest you read the CFE complaint.
Let me answer it this way, Judge Garcia. What we have alleged with respect, for example, to instrumentalities of learning is that with respect to textbooks, that the kids in the unscreened schools are getting dilapidated, out of date, and insufficient supply of textbooks. 3 kids to a textbook. We've alleged that there is not paper, which is one of the things that was talked about in CFE. We have alleged that there are not markers. We have alleged that there is not lab equipment.
Those are very general allegations, but again, in the CFE complaint, they seem to have specific numbers as to the disparities that they were alleging, rather than, there's no markers, there's no toilet paper in one school. Those are the type of allegations I see in your complaint.
We have, let me answer that this way, Your Honor. We have alleged a number of the specific sorts of inputs, deficiencies that Your Honor and I are talking about. If they do not have the particularity with which you are describing, I want to say 2 things. First of all, because we're on a motion to dismiss, all facts are treated as true.
We said in Aristide, and you've made this point before, but we said in Aristide, although it is a liberal standard, it's a standard, and there's a reason for the standard. And we said that in Aristide in one of these cases. So how do you meet that standard with these types of allegations?
In Aristide, the problem was that there were no allegations of causation. that the specific problem was you couldn't get from the input claims to the output claims. There were arguments about a $290 million deficit. There was a general argument that certain schools didn't have what was required. But in terms of the actual causation, the linkage, that was missing, and that if that were missing in our case, then it would be a different story.
How, for example, would you say a certain curriculum is causing these outputs?
That is another great question, Your Honor, and the appellate division dealt with that at pages 297 and 300 and in footnote 10. Here's what we say with respect to, for example, the curriculum. We say a couple things. We say that the curriculum is outdated. We say that, and I agree with counsel with respect to this, we do make the claim, which was not made previously. We're certainly not barred from talking about additions to the education article. This court said that over and over again. But what we've said is that what these children are getting are textbooks and curriculum that demean or ignore certain cultures. For example, at paragraph 116, we talk...
That's still, assume that's true, has to cause a deficiency in a sound basic education as we've defined it, which is real, standard, but limited in certain ways.
And we make that causation argument. If Your Honor looks at footnote 10 of the appellate division decision, that talks about the fact that the state itself recognized that the sort of curriculum you're talking about, which essentially blocks out other cultures. Kids from K to 5, 83% of the authors they're reading are white authors. And what footnote 10 points out, using the state's own reports, is that the sort of curriculum we say is required, if in fact were implemented, because it's not in these kids' schools, but if it were implemented, would lead to higher academic achievement, would lead to more self-esteem, would lead to critical thinking, and would lead to civic engagement. And that paragraph refers to a growing body of research that supports those claims. The city says, and this is the bottom part of footnote 10, that if these sorts of curriculum were applied, there would be less absenteeism, higher academic performance, greater graduation rates, lower dropout rates, more self-esteem for the kids, and that there would be more critical thinking, and that would lead to more opportunities for higher education, and it would lead to better work, and it would lead to greater civic engagement, it would lead to critical thinking, which is, after all, the essence of that. That meets our standard just on what the state and the city say. And we are extraordinarily transparent in this complaint in that we lay out those experts who have said that if these sorts of curriculum we're talking about were added to these schools, put in place in these schools, the sort of outputs, the dismal, abysmal outputs that characterize the schools where these kids attend, that would address those matters, and that meets our pleading criteria in this
Counsel,
particular
can you
matter.
go back to the outcomes? Because you said you had a list. You really only got to graduation rates. I assume there's more.
There is, Your Honor.
What is properly alleged in the complaint regarding outcomes?
Okay, and I'm tracking, Your Honor, from this court's decision in CFE 2, pages 909 to 914 to 919. Here's the second one, Your Honor. One of the issues is, in fact, what happens with the Regents' diplomas. That is treated as a, quote, virtual key to colleges and good work opportunities. Here's the numbers with respect to that we allege. For black students, the number of diplomas is 8%. 8%. For Latino kids, it's 12%. 12%. That is markedly lower. It's almost a quarter lower than what white and Asian kids are getting. It's more than a quarter. It's 4 times less than what those kids are getting. that access to Regents diplomas is part of CFE 2. A third area that we have alleged is with respect to the specialized schools. And that's why that's so important, Judge Halligan, because it's a measure of how these kids are learning, how much they're learning, whether they're even in the game. On those schools, Your Honor, they might as well.
So to make sure I understand, your argument about the specialized schools test is that, is what exactly? That the
It is
disparate
principally-
success in gaining entrance reflects broader deficiencies in the schools, or is it something else?
That's not the principal argument.
Okay.
The principal argument is what Your Honor touched upon when you were questioning, and that is under the Equal Protection Clause and the Human Rights Law, those schools are shut off to these kids with respect
Yeah,
to.
but I'm asking you to focus on the education article, if you would. What is the nub of the claim about how the specialized school tests bear on your education article claim?
Okay, and I want to answer this as directly as I can. I'm not evading your question. I want to say that the centerpiece are the other two claims that we're talking about. But what I'm saying is it's not irrelevant to the.
But you are making an education article claim.
We
right?
are, and the education article claim is that you can draw the inference from the fact that so few kids get opportunities to go to these schools, that they are getting a deficient education. They're not even in the
So we
running.
should infer from the disparate admission statistics that there are deficiencies in the rest of the city school system?
Exactly right.
How does that causation, the rigor of that causation argument, or perhaps the lack of it, measure up against what the court did in the CFE cases?
I don't think it's as strong as it was in the CFE with respect to the funding. I think it is one reasonable inference to be drawn. We don't need that with respect to the 5 areas that I've talked about, which the court has recognized.
You don't need causation?
No. We need causation, but what I'm saying to Judge Halligan is that with respect to whether or not we have shown the inputs, what I'm saying is the test is, it is one inference that can be drawn. It's not a core inference can be drawn. Our case survives with respect to the education article. Without it, I think it is one inference that can fairly be drawn. Our experts will say that the fact that these kids are out of the running demonstrate that they're at schools where they're not getting the same sort of education. If they were in the screen schools,
I'm sorry, I thought the argument was they're not getting into the screen schools at the same rate because they're not in schools before that offer them a sound.
That is correct. But that's from the very
aren't
beginning.
the students who are getting into those schools, also many of them coming from those same schools?
Say that again, Your Honor.
Aren't the students who get into the specialized schools coming from those same schools?
From the unscreened schools?
Yeah.
Not
Before they get to high school.
what we're saying, Your Honor, is that it's a segregated. Let me see if I answer you correctly. If I'm not.
Just be misunderstanding the process.
I may not be
but-
stating it clearly. I don't. What we're saying is it is a system-wide problem, and that the kids who are going to the screen schools
From the beginning.
from the beginning, those are superior schools. I'm not saying that the other schools are. I'm saying that the other schools do not meet the sound basic education
Has to be
standard.
the argument for an education article.
Exactly right. And it's not a hard case to make, Your Honor. Those kids are not getting the basic inputs they need in each of the categories that Your Honors have identified.
But if the argument, and maybe I have the argument wrong, is from the beginning, they're segregated out of these screen schools, how is it that from the beginning, that are not getting a sound basic education? That sounds like it happens early enough in the process where they haven't had an opportunity
That's what we
to not
allege
get
in
a
the-
sound basic
That's what we
education.
allege in this case, Your Honor, that even beginning in the elementary schools, when kids were getting screened at age 4 to get into these pipelines,
So where is the deficiency in the sound basic education? at
all the
age
way through.
4?
It is a system-wide.
We start at 4, What education have they had there that's not a sound basic education?
I'm saying that is utilized to show, Your Honor, that it's not a pedagogically sound, it is a culturally biased system from day one. But what we allege is precisely what Your Honor is getting at. That is, from elementary to middle to high school, these kids who are going to the unscreened schools are not receiving a sound basic education.
But aren't the kids that are going to the screen schools getting the same, they're going through the same educational system, are they not?
They're in name, yes, but it's a two-tier system, Your Honor. It is the segregation, which is the engine here, and which is separating kids into schools that meet sound basic education and go way beyond
So
it.
what's missing in the racially segregated schools with respect to the students that you're talking about are denied the sound basic education?
They're missing the 5 inputs which
ahead.
this court has recognized. The instrumentalities of learning, the textbooks are out of date, they're dilapidated, there's not enough of them, 3 kids to a textbook, they don't even have paper, they don't even have markers.
Are you comparing that to what the screen schools
I'm just
have, or just as a general
As an
assertion?
absolute matter, Your Honor, as an absolute matter. If we want to make the comparisons,
No, I'm asking you.
I'm saying to you, as an absolute matter,
That's what you alleged.
that is what we are alleging.
Don't even need to look at the screen schools.
Exactly right.
Okay.
We do, when we get to equal protection, we can talk about what
Yes,
happens.
but I'm saying for this
But
argument.
absolutely right. If it were a system of itself,
Okay, so it's the book, go ahead.
okay.
You said there were 5.
With respect to the physical buildings themselves, we allege that these are the parlous state of the conditions there. They are overcrowded. There are leaky roofs and hallways. There is vermin in those schools. Those buildings are dilapidated. They are unsanitary. With respect to arts, sports, and extracurricular activities, which this court has recognized, these kids don't have a shot at that. They don't have those sorts of opportunities at all. Sometimes when they're even in the same building, they don't have those sorts of opportunities. With respect to teachers, what we allege is that the teachers there are not recruited, they are not retained, and they don't get the supports they need as an absolute matter. And with respect to the curriculum, what we're arguing is that
These are perennial arguments, also a system that existed at the time CAFE 1, 2 were filed.
Say that again, please.
It's a perennial argument. These are the traditional arguments made regarding funding, regarding the differences in the school system.
We are not, in terms of the inputs,
Yes.
Your Honor is exactly right. These are garden variety inputs that the court recognized in the CFE cases and have repeated many
And
times
I
over.
thought in CFE they had specific numbers on types of degrees, the reviews of those particular teachers. They had specifics as to those teachers and how qualified they were to teach a core curriculum. And this does not sound like CFE allegations to me.
What I meant to say, Judge Garcia, is that they are within those established categories. The argument with respect to teachers is that they have the least experienced teachers. And in addition, with respect to those teachers, again, I go back to the paragraph, page 300 of the appellate division opinion. What we're saying there, may I finish my answer to your question?
Yeah.
What I'm saying there, Your Honor, is that what those numerous studies have showed, what the research demonstrates, and what the experts all say, and what we will show at trial, is by not having a diverse body of teachers, and we have multiple allegations on this, that is not present in their schools, and there is a causation factor with respect to the matters I've talked about, academic achievement, with respect to graduation, with respect to dropouts, and we are prepared to prove that is a factual matter, that absence.
May I ask one question, Chief? On the state HRL claim, right, 296-4, I think, requires proof that you've been denied the use of facilities to a person otherwise qualified. So can you point me where in the complaint you allege that there are students who are denied admission and are otherwise qualified, just the paragraphs in the complaint?
Those are the paragraphs that describe the plaintiffs themselves and the organizations
And
themselves.
so your view is that they allege that the students are otherwise qualified?
But that's where your Honor's questions about the tests come in, because to the extent that they are using those tests, and there's no disagreement here, and incidentally, the city expanded that test to 5 other schools that they called specialized schools. But with respect to those tests, what we are arguing is that is a phony way, it is a pedagogically unsound way, it is an inappropriate way to determine who should get into those schools. And that there are children who, if they were going to the schools that met basic standards, and even for some who did not, that they don't have a fighting chance because the use of those tests have no basis whatsoever. That is a clear violation of 296
So
section.
you're resting
section 4.
on deficiencies in the test as opposed to anything about the pool of students you say who are
Exactly right.
denied? Okay, thank
Exactly
you.
right.
So now I do have one more question for you, back to the Constitution claim. So you've said that some of the schools in the city are providing a sound basic education and some are not.
Correct.
And for some of the failures or inputs, we want to call them that you identify, they are perhaps not things that are directly funding related, but some of them, like a leaky roof, substandard facilities, and so on, perhaps sound more like a funding claim. But I didn't understand, and maybe I misunderstood, that you weren't really bringing a funding claim like the CFE cases. Is that right?
We're not saying that the reason that those are leaky roofs isn't because the state hasn't funded those schools properly. We're saying that the system is not working.
Right, so does that mean that you think that the state has provided sufficient funds to the city and the city is misallocating the funds?
What we're saying, Your Honor, is that that is a factual matter to be developed at trial.
I wonder what you pleaded is what I'm asking.
But what we pleaded is that the buildings themselves, as you and I are talking about right now, is a causation, is what's causing the outputs. And with respect to what caused the leaky roofs and the buildings themselves, we're saying that that is a result of a segregated system that is not giving these kids their constitutional due in terms of
So just to
that.
be clear, so you're not saying that there's a lack of funding?
We haven't identified that
Okay,
as yet,
right.
as what
That's- yeah.
the facts may in fact develop with
Well,
respect to
I'm
that.
asking what you're pleading, right? Because we're going to limit you to the pleading. So if you haven't pleaded that, the facts may show something that you didn't plead and you're not recovering for
But
that.
what we have alleged is that the segregation in the system itself has put these kids in buildings which are not capable of getting the
I
outcome
understand that
results.
part of it. I just wanted to confirm my understanding. You're not really making a funding claim like the funding claims in CFE.
That is correct, Your Honor.
Thank you.
Thank you all.
Thank you. I'd like to briefly make 2 points that are somewhat related and both arise from CFE 2. I understood plaintiff's counsel to identify 2 categories of deficiencies in his argument. One of them was the traditional CFE inputs that we talked about, and I understand him to have just acknowledged that those deficiencies are not attributable to the state. And also, I would note that in the complaint, they are pled in a conclusory fashion as compared to the other more aspirational inputs that are in the complaint. And as to those, I would note that this court held in CFE 2 that state guidance, state standards, regents diplomas, these are aspirational standards, not the constitutional floor that the education article sets. And one last point I'd like to make is that in CFE 2, this court noted the importance of setting clear parameters for education article claims. So to the extent anything proceeds, it's important that the court set clear parameters. And I didn't hear much about arguments about the curriculum or diversity teacher workforce. And so the court should make clear what can go forward so that this court looked at the experience of New Jersey and noted the 12 different trips back to the New Jersey Supreme Court in the Abbott litigation and emphasized the importance of, at an early part of the stage of the litigation, giving clear guidance so that the parties will know what is expected of them. Thank you.
Thank you.
Your Honors, I'd like to make a brief causation point on the education article claim before I talk about the human rights claim. This panel twice asked my friend to identify where the causation was for the outputs, and twice he said, great question, and then pointed to the first department's decision. And I've explained how the first department really got this factually wrong. My plaintiffs have really provided a cheat sheet to this court to see where 0 allegations of causation exist. Read their brief. Every time they say, we alleged causations between the input and the output, they cite to the first department decision or they cite to nothing. There is nothing in the complaint alleging causation, and that even applies when you get to the facilities argument. They say there are these poor facilities and textbooks. They never make a causal connection to poor graduation rates. Last point on the output, you can't just say white people graduate at 84%, black people graduated at 76%, Latino people graduate at 74% and say that's a bad output. We have no context for that. You need to compare that to other statewide districts to understand. That could be the best in the state. We don't know. You could add 10 percentage points to that and just assert.
The best might not be enough as a matter of law, correct?
No, that's.
What you are describing or defining as the best, as a matter of law, the court might say, no, it's not.
I don't think that that's something that could be said as a matter of law. I think that if you're alleging this, we're talking about a baseline education. You need to understand how this compares to have any idea, because they could add 10 percentage points to that and just make the same assertion. You don't get to go forward on that kind of output allegation. That's CFE, where they very specifically looked at the test scores, the graduation rates, and compared them to other states. I mean, you can go through that. That's what they did. They compared them. That's how they knew that they were poor. Okay, I'll get to the state human rights law claim because this is important.
It is important, but let me limit you to a minute because you've had several chances to do it and you dodged them before. So you got a minute and that's it. I'm going to cut you off.
Okay, thank you. The court took a very simplistic approach below, and it just said, well, because they ignored this court's precedent, which basically says our state human rights claims track the federal claims. That's the easy way to resolve this. The court just didn't look at that, and it said, well, because you allow for disparate impact claims to go forward under the employment, then we should, there's not really a good reason not to allow them to go forward under denial of access to education. But that's not a proper way to look at that. It's not textual at all, and it ignores this court's precedent saying that the state human rights claims laws track the federal laws. And we know that
Doesn't
under
the executive law tell us not to do that?
I'm sorry, I didn't hear the
The
first part.
executive law tells us not to do that, not to look at federal analogs.
Well,
Is that right?
this court has rejected that idea very recently in McCabe. It did it in Doe v. Bloomberg, where we said we're not just going to look at that and ignore the text and the history of the statute and say that we're not going to do that. So if you take a textual approach here, it's really clear that this is supposed to be about intent. By reason of, that's what it talks about, that you're discriminating by reason of, denying the use of facilities, permitting harassment. That is all very about intent. Now, you can look to the employment context, and that because of language exists there too, but that's not why the Supreme Court in Griggs, in Inclusive Communities, said that that's why it can go under disparate impact. It said it for a very different reason, because there were parts of the statutes there that said, for instance, otherwise make unavailable. It refers to the consequences of an action rather than the actor's intent. And my position is that you can look at 1A, 296-1A, and that kind of language exists there. It's not the because of.
Please wind yourself up.
Okay, it's something else. And I'd say the first department just didn't do any sort of textual analysis, and a textual analysis here would allow you to both find that the claim they bring under denial of access to education requires intent, and in the employment context, that a disparate impact can go forward. Thank you, Your Honors.
Thank you, Your Honors. I'd like to make a point just about the core of the justiciability doctrine and relate that back to the plaintiff's claims here. So at its core, justiciability is about what the court is able to manage as opposed to sort of policy, education experts. And what the court requires in order to do that is it must have a judicially manageable legal standard. That's the kind of term this court and other courts have used to describe the justiciability doctrine. And so you can see the difference here between plaintiff's claims and the kind of claims that are justiciable. So in CFE, for example, the plaintiffs came in and said, This entire district lacks the required minimum for sound basic education. They're not hitting minimum graduation rates. They're not learning the basics of reading, writing, mathematics. That's different from what the plaintiffs are claiming. And if you, my friend on the other side came up here and he talked about, that we would have better graduation rates if the city adopted the curriculum plaintiffs prefer. We would have more equitable admission rates if the city adopted some kind of different test. Things would just be better if plaintiffs' preferred policies were adopted instead of the policies that the city has in place. That is not a judicially manageable standard. If this court were to let those allegations move forward, we would be back here in a few months, in a year, deciding whether the policy that the city adopted instead meets the plaintiff's preferred criteria for just how good the city has to be before it meets that standard. That's not a judicially manageable standard. In practice, this is not a justiciable case. Thank you.
Thank you.